Miltons IP in Ottawa, Canada. And I wanted to share with you my thoughts, what we've learned about patent prosecution highway practice, and then to invite you to provide your lessons learned, your feedback, your questions, your comments. The patent prosecution highway is actually a whole series of bilateral agreements between various patent offices. So in the absence of a treaty to streamline prosecution, what we have is a series of deals between various patent offices about how a mutual recognition of their respective examination processes. Really, it's a mutual recognition deal between various countries. Because there are so many countries participating in these bilateral deals, there's the potential for very complex scenarios for prosecution. But what I want to share with you is two really simple thoughts. The first simple thought is that most of those complex scenarios are not nearly as important as understanding the crucial fact of early examination. A fundamental component of most PPH agreements is that prosecution must have been completed in the primary jurisdiction, what's often called the first filing office. I call it the primary jurisdiction, before examination commences in the secondary jurisdiction. Now here in Canada, that's really easy to orchestrate. That's a basic part of Canadian patent practice. For instance, say you file in the United States and you file in Canada a convention application at month 12. It's very straightforward to prosecute under the normal course under the USPTO and to prosecute to allowance before ever starting examination in Canada. That's because we have what's called deferred examination. You can defer examination for up to 5 years without cost, but it's really not a deferral. You just don't do anything. In fact, to get examination started, you must request examination and pay a fee. So it's very straightforward and easy to defer examination in Canada while the application is being prosecuted in the primary jurisdiction, especially if that's the United States. But that's not true for many other pairs of countries with PPH agreements. You know, think about the EPO and the USPTO. If you file even at month 12, in one, examination will likely have commenced in both long before there's an allowance in either place. So that defeats the whole purpose. From that, however, you can develop Milton's law of PPH, which is you must accelerate examination. You must move it as quickly as possible in the primary jurisdiction. Otherwise, you will not be able to invoke the PPH in secondary jurisdictions that matter, like the EPO. So that potentially sets up a radical transformation of patent practice from the traditional. You know, you can't file a provisional at month 0 and lollygag your way through to month 12 and then, oh, I'll file something. Oh, and then I'll just ignore the search report and I won't pay much attention to the written opinion. And at month 30, we'll file the regional phase in the EPO. If you do that, you've blown it. To take advantage of the PPH, what you need to do, in fact, is accelerate examination of the claims in the United States as quickly as possible. So that may mean filing the full-blown utility application quickly. It may mean paying the accelerated examination fee. Now, normally you think, wow, that's a lot of money. But yes, that's a lot of money, but it could be a very, very worthwhile investment. If every dollar spent on accelerated examination in the United States saves multiples of that money in decreased prosecution costs in other jurisdictions. So for instance, if you eliminate your prosecution costs in Europe, that may very well offset and more the accelerated exam fees that you had to pay at the USPTO. So that's the first point I wanted to flag for you. Here in Canada, it doesn't matter, and that's why we've gained so much PPH experience, is because almost every application qualifies. But if you're trying to go from the US into Europe or Europe into the US, you've got to make some changes. Otherwise, you don't have very many applications that will qualify. The second thing that we've learned is that it makes a big difference to practice and to money. Yeah, I know, that's the elephant in the room. No one in our business ever wants to talk about money. But you know, patents are a business tool. they're a tool for businesses to make money, and they can be extremely expensive. The PPH has the potential to make prosecution in multiple jurisdictions better, faster, and cheaper. So for applicants, this is a potential huge boon. It potentially makes it possible for applicants to get much broader scope of protection, the same claims in more jurisdictions than they were getting in the past. For applicants, at the same or reasonable cost. For applicants, that's a huge win. For patent attorneys, it also has the potential to be a huge win, both for drafters in the primary jurisdiction and the recipients in the secondary jurisdiction. You know, in the past, many patents were filed in the United States, for instance, and not filed anywhere else. And I think one of the reasons was that it was too cumbersome, too expensive, and too confusing to file other places. You know, it used to be that patent prosecution in multiple countries was sort of the death of 1,000 cuts. Every 6 months, you'd get another piece of paper in a different language that needed a translation, and there were fees to be paid, and you probably had to get something notarized and signed in red ink with your left hand while you were wearing a blue shirt. You know, it was complicated, it was expensive, and if you were instructing your client or giving your client advice, it was extremely difficult to know how long things would take and how much they would cost. Clients hate that. Now, the PPH makes it possible to provide a lot more certainty. At least the way we've organized our practice is we can do them on a flat fee basis. We can tell you straight up that a small entity will cost about $4,000. A patent application from application to grant for a small entity in Canada will cost about $4,000, not including maintenance fees. Our associates can then turn to their clients and say, well, here it is. You want to go for it or you don't? You can add reasonable fees, not outrageous fees, but reasonable fees on top for providing that service to your clients. So it's a huge boon to the instructing attorney. It's a huge boon to the client, especially in-house attorneys. Less paperwork, less cost, more certainty, much easier to budget, much easier to provide information to other internal stakeholders. And lastly, you know, it's worth thinking about the patent offices. It makes a big difference for them. I'm not sure exactly yet who's going to be the winner in all this, but it's really worth thinking about. My understanding is that the PPH agreements were initiated by the USPTO with a hope of having some of the prosecution and the examination done elsewhere so that every patent filed wasn't examined from start to finish in the United States. It sounds like a laudable goal. I'm not sure it's coming to pass. At least here in a place like Canada, I suspect that the PPH is a boon for the Canadian Patent Office, but not really such a great deal for the USPTO. And why do I say that? Well, for the Canadian Patent Office, they still get all the fees, but they have to do much less substantive examination on the applications where Canada is a secondary office, where the PPH is invoked in Canada. So a cash cow, effectively, on those applications. I don't foresee that there's going to be a lot of action going the other way, that there will be a lot of applications that are examined in Canada and then the PPH is invoked in the US. I could be wrong. You may tell me that I don't have it right and there are lots of you doing it, but I suspect, just knowing the way things are, I suspect that many more applications will continue to be examined from start to finish in the United States, and the PPH will be invoked in Canada. So I think it's a cash cow for Canada, and I don't see it causing the USPTO any harm, but I don't see it achieving the goal that they'd hoped, at least in that pair. Now, other pairs, the outcome may be different. The Korean Patent Office or the EPO, things may go differently in different bilateral pairs. But it's worth thinking about, it's particularly worth worrying about if the patent offices don't get what they want. But I actually think that what we're going to see is more patent filings in multiple jurisdictions. And the reason I come back to the impact on both attorneys and applicants. Applicants will see the ability to get more rights in more jurisdictions with certainty and without enormous cost, and attorneys will see a potential new revenue source. Another argument is that if you use as the primary jurisdiction a country outside of the United States and use the US as a secondary jurisdiction, you get a very clean, simple US file wrapper. And that's true, and it's a compelling argument. It means that the public record will be very short and very sweet. I don't want to overplay that, though, of course, because it does mean that while the public record is simple, in any litigation, your disclosure obligations probably extend back to the entire prosecution history in any event. But it is a countervailing force against my earlier contention that maybe you might not want to use Canada as the primary jurisdiction. So that's a possible argument. Another important consideration for using the PPH is the value of getting a consistent set of claims allowed in multiple jurisdictions. You know, if you file in more than one country, pretty soon you'll end up with disparate claims. That can be a nightmare, especially if you have a large portfolio. So while you may give up a little bit that you could gain in prosecution in one country here or one country there, in addition to all the potential cost savings during the prosecution phase, in my view, there's enormous potential benefit from a portfolio management perspective to have a consistent set of claims in multiple jurisdictions for any given patent. Those are my thoughts. I look forward to hearing your comments, your feedback, what's working for you, what's not working for you, and especially about other bilateral pairs that we may not have nearly as much experience with. Send me an email, call me. I look forward to hearing from you. I will try to share the best information that I get with all of us so that we can develop a community that's interested in PPH practice. Thank you.